As I got the information, all the participants are here. Do I have the permission to start the tribunals?
Yes, please.
Thank you. Welcome to the final round of the third edition of the International Arbitration Moot 2023. In collaboration with Denton's Link Legal and Guyarat Maritime Cluster, hosted by International University of Sarajevo and supported by Careers in Arbitration. This round is between Team Code 03 and Team Code 17. I wish to extend a big congratulations to all teams for advising till the final rounds of this competition. I'm Oben, and I will moderate this final session. I would like to welcome all the worthy participants today and would like to welcome and thank our arbitrators for volunteering their time today. And I would like to also share some general guidelines for the session. The claimant shall be allowed a total time of 30 minutes to speak, and the respondent shall be allowed 30 minutes for arguments. The division of the time between the team members is the discretion of the team member, subject to a maximum 18 minutes for each speaker. Please note this time will include the time for rebuttal as well as sub-rebuttal. Now, please, all the participants are please requested to write in the chat box their team code along with their role in the team and how they wish to allocate their time. In the meanwhile, I would like to take this opportunity to introduce the eminent arbitrators for this competition. Mr. Joe Trado. Welcome, ma'am. Welcome, sir. Joe Trado has over 30 years of dispute resolution experience and has handled hundreds of cases across a broad range of industry sectors as counsel, arbitrator, mediator, conciliator, adjudicator, and expert determiner in more than 65 jurisdictions. Mr. Joe is co-head of International Arbitration, ADR, at leading Spanish and Latin American firm Gary Gass. He has represented sovereign governments, multinational corporations, and individuals. Mr. Joe has handled high-value cases in a number of sectors and industries, although he is particularly well known for his work in the energy field. Mr. Joe has conducted and advised on international commercial and investment arbitration under all the major international arbitration rules before the leading international arbitration institutions, as well as pure ad hoc and ancestral arbitration. He has also conducted and advised on a number of mediations and other alternative disputes resolution processes. Mr. Joe is a solicitor advocate with full rights of audience before all civil courts in England and Wales, an accredited commercial and investor state mediator, a civil mediation council fellow, an ICSID conciliator, and panel member of a number of leading invitation-only arbitration and mediation panels, including the European Union and the United Nations. Mr. Joe writes extensively and presents regularly on international arbitration and ADR at major international conferences, symposia, and seminars and prominent universities around the world. Mr. Joe is contributing editor of Global Legal Insights to International Arbitration, Global Legal Group, which is now in its 9th edition covering 67 jurisdictions. He is also actively involved in arbitral and mediation institutions and prestigious international arbitration and ADR associations and committees. Mr. Joe is a past co-chair of the IBA Mediation Committee. Thank you so much, sir. It is an absolute honor to have you among us today.
Thank you for that very extensive and comprehensive introduction. I'm flattered. Thank you.
Thank you. Moving on, our next arbitrator, Mr. Robin David. Welcome, sir. Mr. David has more than 33 years of legal practice as an advocate at the Supreme Court of India, where IHE represents clients in various courts and tribunals across the country. He acts as a governing body member of the Indian Council of Arbitration and contributes to the promotion and development of arbitration and alternative dispute resolution in India and abroad. His core competencies include corporate and commercial litigation, arbitration, constitutional law, administrative law, company law, civil procedure, insolvency and bankruptcy, access to information, mining law, and competition law. He is a fellow of the Chartered Institute of Arbitrations, Indian Council of Arbitration and Prime Dispute, and a registered foreign lawyer of the Singapore International Commercial Court. Mr. David has extensive experiences and expertise in arbitral proceedings under the rules of ICC, LCIA, ICA, and DIAC. Thank you so much, sir, for volunteering your time for this competition today.
Thank you. Thank you very much for the introduction.
Next, we have with us today as an arbitrator, Mr. Shravan Yammanur. Welcome, sir. Shravan Yammanur is a partner in Denton's Link Legal's dispute resolution practice in Delhi. He specializes in international arbitration, public international law, trade law, public policy, and litigation. Prior to joining Denton's Link Legal, Shravan has worked in the government of India for several years at the Ministry of Commerce and Industry and the Ministry of Finance, advising on foreign investment and trade issues. He was a member of India's negotiation team for investment treaties and investment chapters of free trade agreements, including the Regional Comprehensive Economic Partnership Agreements, India-EU Broad-Based Trade and Investment Agreement, and the UK-India Free Trade Agreement. Mr. Shravan was involved in the formulation of India's policies on investment and services issues at the WTO, BRICS, G20, and in free trade agreements. He has represented the Republic of India in investment arbitrations relating to its mining sector, energy policies, and the civil aviation industry. Mr. Shravan is an advocate on record of the Supreme Court of India. Thank you so much, sir, for being a part of this competition.
Thank you for having me. I look forward to hearing the themes and wish you all the best.
Thank you, sir. Our next arbitrator is Mr. Madhavendra Singh. Madhavendra Singh is the founder chief executive officer for the Gujarat Maritime Cluster, the only such cluster in India and the global hub for shipping activities. He is also steering the Gujarat International Maritime Arbitration Center. Previously, he served at the Ministry of External Affairs for Strategic International Diplomacy, External Relations, and Public Policy. He was also a treaty negotiator. He was a senior Indian Navy officer prior to that and was heading the Power Systems Specialist Group at Warship Design Bureau, directing the design, analysis, and implementations of futuristic power systems, hybrid energy storage, renewable energy, and electric propulsions. He is a chartered engineer and a distinguished member of IEEE and designed the only indigenous sonars trainer and the tactical wargame trainer for the Indian Navy. He is fellow of CIARB London and the sporting member and arbitrator with London Maritime Arbitrators Association. He is scholar of UCU Academy of the Law of the Sea and advisor to the Indian Ocean RIM Association, MediateGuru's. He has done the executive program in investment arbitration from Queen Mary University, London. He is on the governing council of MCIA, Maritime Users Council. He is an international arbitrator and member of LMAA, MARC, and other international institutions. He is author and international faculty on international commercial arbitration, investment arbitration, maritime arbitration, blockchain and smart contracts, sovereign immunity, international mediation. He is on advisory and additional board of major international and Indian publication and universities. Thank you so much, sir, for honoring this competition with your estimated presence.
Thank you, Oben.
Last but not least, we have with us today Mrs. Fahira Broadlia. Mrs. Broadlia is a rule of law advisor and project manager for GIZ project dedicated to the reform of the investor-state dispute settlement system in the Western Balkans. She is also the head of the research team of arbitrator intelligence and a lecturer at the International University of Sarajevo. As an expert in international arbitration with a focus on investment disputes, Mrs. Broadlia writes extensively and frequently speaks at the international conferences and seminars. She is a regular tutor of the Chartered Institute of Arbitrators Diploma Program. Mrs. Broadlia is a graduate of the University of Sarajevo and University of Pittsburgh. Since her participation in the Moot program in 2015, Mrs. Broadlia has been a Moot coach and advisor for teams from Bosnia and Herzegovina, the team's Western Balkan region, and the US and Myanmar. Thank you so much, ma'am, for volunteering your time for this competition. It is an honor having you here and being your student.
Thank you so much, Oben. It's lovely to see you, and thank you for your lovely moderation. I look forward to this event.
Thank you. Now, with the permission of our arbitrators, we shall begin by the opening statement of the claimant. Do we have a permission, tribunals?
Yeah, please go ahead. Claimant, what's the team number?
It's team number 03 and team number 17, ma'am.
Thank you.
Good luck, teams.
Greetings to the arbitral tribunal, the moderator, and my learned co-counsels. This is Counsel 1 appearing on behalf of the Federal Republic of Arcadia in the present dispute. Now, would the tribunal require a the briefing of the facts of this dispute?
Yes, please.
Yes. So, the disputing parties are two neighboring nations in the South Asian region, the Democratic Republic of Utopia and the Federal Republic of Arcadia. In 1960, to manage the use of the Zephyr River system, Utopia and Arcadia entered into the Zephyr's Water Treaty. The treaty divided the rivers into two groups, the eastern rivers, including Equor, Pax, and Concordia, for which Utopia was given unrestricted use, and the western rivers, consisting of Unity, Harmonia, and Arcus, primarily allocated to Arcadia. In 2023, a drought resulted in a drastic reduction in the water levels of the Zephyr River system, which affected both countries, which were highly dependent on these rivers. In response to this crisis, the government of Utopia decided to construct a series of temporary diversion channels and barriers on the Western River. Arcadia first became aware of Utopia's diversion projects in early 2024 through the satellite imagery analysis conducted by its National Space Agency. Arcadia then formally approached the Permanent Zephyr Commission, asking for an urgent intervention to assess Utopia's diversion projects. Then, considering the Commission's inconclusive findings and the escalating tensions between the two nations, a neutral expert was appointed in late 2024 to conduct an exhaustive assessment of Utopia's diversion projects, and the report of the neutral expert was released in the mid-2025. Following the neutral expert's suggestion, Utopia and Arcadia entered into a series of bilateral negotiations throughout late 2025. However, despite several rounds of talks, the two nations failed to reach a mutually acceptable solution. In accordance with the provisions of the Zephyr Waters Treaty, Arcadia invoked the arbitration clause under Clause 5 of Article 9 of the treaty, and this court of arbitration was established. This court is tasked with deciding whether Utopia's diversion projects are in violation of the Zephyr Waters Treaty. The court must determine what, if any, remedial measures should be taken if such a violation is found. Additionally, the court is to consider whether Arcadia has suffered harm as a result of these projects, and if such harm is established, suggest appropriate reparations. Now, Counsel 1 shall deal with whether Utopia has violated the Zephyr Waters Treaty and international law, and my co-counsel shall deal with whether Arcadia has suffered harm and the appropriate reparations for the same. Now, if the tribunal is satisfied with the briefing, could the counsel move on to the submissions?
Could you tell us what is your prayer? What is the relief that you seek?
Yes, Mr. Arbitrator. The relief that we seek is to declare that Utopia has violated the Zephyr Waters Treaty and Arcadia has suffered harm, and we require we asked before this honorable tribunal to make Utopia pay us damages basically for the loss, for the harm caused by Utopia.
Okay.
Yes. Could
Please
the
go ahead.
council move?
Yeah, go.
Thank you. Right. So it is humbly submitted that Utopia has violated the Sapphire Waters Treaty. Clause 2 of Article 7 of the treaty talks about engineering works which may affect the other party. Now, it states, if a work would cause interference with the waters of any of the rivers, but would not, in the opinion of the party planning it, affect the other party materially, nevertheless, the party planning the work shall, on request, supply the other party with such data regarding the nature, magnitude, and effect, if any, of the work as may be available. Arcadia strongly contends here that Utopia should have informed about the diversions that are being done on the western rivers. Arcadia had to find out about the same through satellite imaging, and the official clarification given by Utopia did not contain details as to the data of these projects. Considering the ongoing drought situation that is affecting both of these nations, Utopia should have foreseen the potential implications of these projects on Arcadia. The duty to consult and notify is also listed in Principle 19 of the Rio Declaration on Environment and Development of 1992, to which both Arcadia as well as Utopia are signatories. It reads, states must give sufficient notice to states likely to be affected and to provide them with all relevant information on activities that may have serious adverse transboundary effects on the environment, and to consult with those states promptly and in good faith. Arcadia contends that Utopia has violated this provision as well by not providing due notice or any consultation on these diversions. Now, moving on, Clause 6 of Article 4 of the treaty reads as, each party will use its best endeavors to maintain the natural channels of the rivers as on the effective date in such condition as will avoid, as far as practicable, any obstruction to the flow in these channels likely to cause material damage to the other party. Arcadia strongly contends that Utopia has not used its best endeavors to maintain the natural channels of the western rivers due to the obstruction caused by the diversions and its consequential damage to Arcadia. The preamble of this treaty reads that the government of Utopia and the government of Arcadia were equally desirous of attaining the most satisfactory use of the Zephyr River system and fixed rights and obligations on the use of these rivers in a spirit of goodwill and friendship. By virtue of Article 31 of the Vienna Convention on the Law of Treaties, the preamble is also binding on these parties. And Arcadia contends here that Utopia has violated this cooperative spirit, goodwill, and friendship by failing to provide notice to Arcadia on these diversions, and has continued with these diversion projects till date, especially when there are intense negotiations between the two nations on these projects. Arcadia strongly contends that these acts of Utopia are in direct violation of the treaty and its spirit. Now, if the tribunal has any further questions, or if not, the council would like to move on to the violation of international law.
Sorry, Council.
Yes.
You mentioned Article 31, and by your own words, that it declares that the preamble is also binding on the parties.
Yes.
That seems to be a bit of a strong statement, because the Vienna Convention has some primary tools for interpretation and then also secondary, meaning we should look at the text of the provision itself. And then maybe what would you say the role of the actual preamble is, if you would like to be more specific on this, because I'm not sure I would agree that it means that the preamble is binding as such.
Thank you, Lady Arbitrator. I'll try to answer your question. So the reason why the council cites the preamble of the treaty here is to, provide the intention as to the parties entering into the treaty. The treaty intends to, fix rights and obligations with regards to the Zephyr River system. So, and the treaty also intends to make sure that the parties, that is Utopia and Arcadia, ensure that they use waters in the most effective manner, so as to ensure that both parties get the benefits of the rivers. So,
No worries. That is clear enough. But my question is, why should we jump straight to the preamble? Aren't there some primary tools of interpretation under this Vienna Convention? Meaning, we need to look to the preamble and to the object and purpose and other meanings if the text itself is unclear. So, what are you contending in the text is left unclear to the extent that we now have to look beyond that initially?
Well, to answer your question, Lady Arbitrator, we've as per my contentions earlier, I've tried to point out that there is that Utopia has violated certain provisions of the treaty. The Council cites the preamble to point out that the intention of the treaty is to ensure cooperation, and Utopia has not cooperated by not providing us with data as to the projects, as well as they've continued with the projects when there are discussions and debates with regards to the same as well. So that was the primary intention behind this council to bring the preamble into question here. Does this answer your question, Lady Arbitrator, or would you require further?
Yeah, we might come back to this later, but yeah, you can proceed unless other arbitrators have questions.
Yes, Lady Arbitrator. Yes, so moving on, Arcadia submits that Utopia has violated various principles of international law, particularly the principle of equitable and reasonable use, the duty to cooperate in the management of shared watercourses, and the principle of pacta sunt servanda. The principle of equitable and reasonable use is based on the notion of the existence of a community of interest among all co-basin states, which ultimately requires a fair balancing of state interests to accommodate the needs and uses of each state. Barrett, in his work, argues that the concept of equitable and reasonable use is normatively vague to permit flexibility. Lipper argues that the principle is to be determined according to the facts and circumstances of each individual case in light of all the relevant factors, including the human, economic, and social dependence of each state and environmental concerns upon the water resources in question. The doctrine of equitable and reasonable use has been used in various international cases, particularly in the Gapchikova-Nagiamoros case, where the ICJ accepted the principle as a general law. The ICJ further held that watercourse states shall participate in the use, development, and protection of an international watercourse in an equitable and reasonable manner. In that case, Hungary was deprived of its rights to an equitable and reasonable share of natural resources of the river Danube by Czechoslovakia, and also failed to respect the proportionality that is required by international law. Now, the Council would also like to cite the sinking of the river Danube case between Prussia, Württemberg, and Baden in Germany in 1927, where the tribunal held that when a state uses a portion of an international water basin passing through its territory, it is bound by the principle that derives from the idea put forward by the community of nations, which is not to harm another state. States located within the same basin must duly consider the requirements of the other states and not substantially affect natural possibilities for the provision of water to a neighboring state. A state should not refrain from changing the course of a river at the expense of its neighbors, and should make sure that there are no violations based on the expected behavior of states with regards to their rivers. In the present dispute, Utopia has violated the doctrine of equitable and reasonable use. Utopia, though having territorial jurisdiction, should not have made the temporary diversions, particularly in a situation of drought. This act of Utopia violates the right of Arcadia to receive waters from the western rivers. Moving on, the duty to cooperate in the management of shared watercourses is a seminal principle of international law, finding its place in Article 8 of the UN Watercourses Treaty. The general obligation for states to cooperate highlights that all states affected by the proposed planned measure have equal right to cooperate and be cooperated with to ensure that optimal benefit is derived from the water as well as adequately protected from harm. The principle of equitable participation recognizes that it is only through the cooperation of states that equitable and reasonable utilization can be achieved. It implies intentionality in cooperation among riparian states. Now, the principle of pacta sunt servanda is a central principle of international law. It enjoins states to uphold agreements entered into and to do so in good faith. Under Article 18 of the Vienna Convention on the Law of Treaties, a state is obliged not to carry out acts that will defeat the purpose of a treaty to which it is a party. Article 26 mandates states to perform their duties as enshrined in treaties to which they are a party with good faith. By virtue of the constructions in these diversions without prior notice, Utopia is in clear violation of Pacta Sunt Servanda. Hence, Arcadia contends that Utopia has violated the Zephyr Waters Treaty and international law. Now, with this, the submission of this council ends. Now, if the tribunal has any questions, the council shall be happy to answer.
You've referred to a multilateral treaty. Can you just scroll up? Are Arcadia and Utopia parties to that treaty? Do you have anything on record to show that? You can scroll above that. The Watercourses Treaty
Yes.
of 1997.
Yes.
And what's the relationship, given that it's a multilateral treaty and there's a specific bilateral treaty applicable to these rivers? What is the relationship between these two treaties? And please answer the first question, whether these nations are parties to this treaty.
Yes. Yes, Mr. Arbitrator. Firstly, both Utopia and Arcadia are not signatories to the UN Watercourses Treaty, which in effect means that the provisions of this treaty do not bind both of these nations. The Council cites this treaty with regards to the Zephyr Waters Treaty in order to point out that the provisions of the treaty are a collection in a manner of various international principles with regards to transboundary disputes. So, since the treaty gives a very clear explanation as to the responsibilities of nations, the Council cites this treaty in a persuasive value to just point out that the international discourse on transboundary river disputes is in this way, and Utopia's actions are not in line with the same. Now, does that answer your question, Mr. Arbitrator?
You can proceed.
Yes. So the submissions of this council ends here. I'd like to give the dais to my co-counsel, who shall deal with whether Arcadia suffered harm and the appropriate reparations with regards to the same.
Greetings to the Arbitral Tribunal. This is Council number 2 appearing on behalf of the claimants, that is Federal Republic of Arcadia and the instant dispute. If the tribunal permits, I will be proceeding with the rest of the issues.
Please go ahead.
Thank you, Mr. Arbitrator. So the rest of the issues are whether Arcadia has suffered harm due to the diversion project, and what are the appropriate reparations to be given to Arcadia if such harm is caused. So it is humbly submitted that Arcadia has suffered harm due to the diversion project. The council shall in detail explain as to the harm suffered in two folds. Whether an apprehension of harm in the neutral expert report is sufficient. Secondly, whether the principle of no significant harm obligation is violated. To begin with, yes, Arcadia has had an apprehension of harm through the neutral expert report, which was recommended by the commission, approached by Arcadia, seeking for an urgent intervention to assess Utopia's diversion project. Apprehension means, and it is an awareness that any injury or offensive contact is imminent. Whether an act would create an apprehension in the mind of a reasonable person varies depending upon the circumstance. The council shall establish in the course of the argument that this apprehension is more than sufficient to establish harm. Annexure F of the Zephyr's Water Treaty talks about the neutral expert. Firstly, clause 11 states that the decision of the neutral expert on all matters within his competence shall be final and binding in respect of the particular matter on which the decision is made upon the parties and upon any code of arbitration established under the provisions of Article 9. Therefore, the neutral expert report can be relied upon as it is binding upon both the parties. The council shall rely upon the expert's report to establish that there was harm caused to Arcadia by the diversion project. Arcadia is suffering immensely due to the diversion project started off by Utopia. Firstly, the facts establish that both countries are facing a drought situation. The facts also establish that the diversion structures were aimed at diverting the additional flow of the western rivers. Arcadia strongly contends that if the water levels have reduced due to the drought, where does the additional water flow come from? Secondly, para 9 of the proposition clearly explains the findings of the neutral expert report, which reads as: the report acknowledged the severity of the drought situation and utopias need to safeguard its citizens and agriculture. However, it also pointed out that utopia's diversion project, while temporary in nature, could potentially have a significant impact on the downstream flow of the western rivers, thereby adversely affecting Arcadia, especially given in its high dependence on these waters. The findings of the neutral expert report states that Poseidon irrigation scheme has been designed to divert water primarily for irrigational purposes, with limited provision for returning the water back to the river. Clause 13 of Article 4 of the Sapphire's Water Treaty states that such part of any water withdrawn for agricultural use, each party will use its best endeavors to return to the same river all water withdrawn therefrom for industrial purposes and not consumed either in the industrial process for which it was withdrawn or in some other domestic use. It can be clearly established that utopia is clearly violating the provision and has not used its best endeavors by not taking into consideration the ongoing drought and its effect on both countries. Thirdly, it is stated that even though the Neptune hydroelectric project is not intended to materially affect the volume of water flowing into Arcadia, it could influence the timing and intensity of the flows. Clause 6 of Article 4 of the treaty states that each party will use its best endeavors to maintain the natural channels of the rivers as on the effective date in such condition as to avoid, as far as practicable, any obstruction to the flow in these channels likely to cause material damage to the other party. Moreover, Clause 9 of Article 4 of the treaty also states that each party declares its intention to operate its storage dams, barrages, and irrigation canals in such manner consistent with the normal operations of its hydraulic systems as to avoid, as far as feasible, material damage to other party. Therefore, altering of the time and intensity of the flow of water will affect the natural channels of the river, which will eventually cause material damage to Arcadia. With these two findings, it can be clearly inferred that there's no certainty that Arcadia will get their western waters back. To conclude, as per Clause 14 of Article 4, which states that in the event that either party should develop a use of waters of the rivers, which is not in accordance with the provisions of this treaty, that party shall not acquire by reason of such use any right by prescription or otherwise to a continuance of such use. Therefore, it is urged that Utopia should stop the construction of the diversion as it is not in accordance with the treaty and it has the potential to cause significant harm to Arcadia. The second sub-issue is whether Utopia has violated the principle of obligation to not cause harm. Obligation to not cause significant harm has been envisaged in the Convention on the Law of Non-Navigational Use of International Watercourses 1997. Here, Article 7 states that watercourse states shall, in utilizing any international watercourse in their territories, take all appropriate measures to prevent the causing of significant harm to other watercourse states. Where significant harm nevertheless is caused to another watercourse state, the state whose use causes such harm shall, in the absence of agreement to such use, take all appropriate measures in consultation with the affected state to eliminate or mitigate such harm, and where appropriate to discuss the question of compensation. The principle of the obligation not to cause significant harm derives from the maxim sic cuter tu ut alienum non ledus, which means so use your own as to not harm another, which is perfect fit with the principle of equality of sovereignty between states in general international law. The no harm principle entails that prohibitive and preventive elements as well as remedies. It forbids states to cause significant harm. It obliges states to take adequate measures to control or regulate sources of potential harm in advance, and it calls for reparation for the harm done. This principle finds its origin in the Trail Smelter case between the USA and Canada in 1941. Although the case is about transboundary air pollution, it also dealt with aspects of transboundary harm caused by uses of water resources. It stated that states shall not use their territory in a way that may cause injury to another state. Moreover, in the Lake Lennox case, the no harm principle was firstly affirmed by the tribunal by way of obiter dicta, stating that there was a rule prohibiting the upper riparian state from altering the waters of the lower riparian state. as enumerated by the ICJ in the pulp mills on the Uruguay River case. Every state's obligation is not to allow knowingly its territory to be used for acts which are contrary to the rights of other states. A state is thus obliged to use all means at its disposal in order to avoid activities which take place in its territory or in any area under its jurisdiction, causing significant damage to the environment of another state. This court has established that this obligation is now a part of the corpus of international law relating to the environment. Therefore, it is clear that.
Excuse me, counsel. You are referring now to the principles and to the rules, and some of them, like my colleague previously mentioned, some of them are not even binding on the parties here. So just to bring you back closer to our case, what is it exactly that you are indicating here that is the significant harm, or are we talking about potential harm that could be caused by this alleged violation of this treaty? So are we speaking specifics? Because we're still waiting for this direct allegation against the other side, except for taking measures without prior notice.
Thank you, Lady Arbitrator. To answer your question, firstly, the cases that I've cited is just to throw light on the no harm principle, especially the Lake Lennox case, as it's affirmed firstly by the tribunal about the no harm principle. Even though it's not entirely binding, it gives a persuasive value to show that there was harm caused, and such cases are taken or cited in order to throw light on the no harm principle, and which is violated in the present case. Secondly, what was the other question, Lady Arbitrator? Could you please repeat?
No, it's perfectly clear that you are indicating these cases as example and as guidance, but for our specific case, so on our facts, what is it specifically that's significant harm that you are alleging? What is it that we are seeking to remedy here?
In this particular case, there's a potential harm that could cause to Arcadia due to the diversion project. As stated by the neutral expert report in para 9 of page 6 in the proposition, it shows that Arcadia, the water is flowing downstream, which means it's a advantage to the upper riparian state and a disadvantage to the lower riparian state. So
but
building a diversion.
I'm sorry, counsel, but the cases you cited are talking about potential environmental harm that needs to be remedied in collaboration with both parties. The fact that this measure puts one state in an advantage over another, it doesn't really align with the kind of breach you are claiming. So do you have a case where such a potential economic effect or other harm is considered a breach of these duties?
Yes, Lady Arbitrator, in the Uruguay River case, it shows that activities which take place in the territory in any area under jurisdiction causing significant damage to the environment of another state. So as I mentioned before, since Utopia is creating a diversion channel which could significantly impact the environment and the irrigation channels of Arcadia, because they are also entirely reliant on that river, and creating a diversion channel is going to stop their water flow and their water supply to the irrigation fields and environment as well. So this could have a potential damage, and a high harm is clearly evident in the
Clement Counsel. Can you please tell me that how did your party get to know of these developments on the side of Utopia?
Yes, Mr. Arbitrator.
Is it through satellite imagery, and in anticipation you're basically anticipating harm to your?
It is not anticipation, Mr. Arbitrator. It is through the satellite imagery analysis by our National Space Agency. They were the ones who mentioned, who clearly told us about the diversion channels and the construction, which could have a significant.
You have not brought out the quantum of damage that you're talking about. Like my colleague also mentioned, we are still waiting for you to quantify your damage and tell us what exactly happened, rather than telling us that this could happen, that could happen. And also, what is the interplay between the sovereign right of a nation to for the preservation of its human life, to utilize its own resources? And when you're talking about a bipartite or a bilateral treaty in comparison to the multi-party, which takes the precedence, and what is the lex specialist that we're talking about here?
Mr. Arbitrator, could you please detail it, tell me as to the question which I have to answer?
Yeah, because see, all that emerges from your arguments to me is that through the satellite imagery, your party actually got to know the developments are happening, and in anticipation, you have brought up this case in front for the tribunal to basically adjudicate, where you're not talking about the quantum of the damages that have happened. And then secondly, also that like Utopia, what is the interplay of their sovereign right to utilize their resources on their side of the country for the, preservation of the human life in their part of the country? And also, how does the multi-party treaties take precedence, or the bilateral treaties take precedence over the multi-party, and which is significant here?
Mr. Arbitrator, I'm sorry. Could this council answer your questions? Would that be fine? Could I answer your questions? Would that be fine with you?
Sure, yeah.
Yeah. So, firstly, yes, there were, to clarify, firstly, there was intense negotiations between the countries before entering into this, before coming to this honorable tribunal. These negotiations proved no fruit, which is why Arcadia invoked the arbitration clause, and we're here right now. Secondly, the facts clearly point out that that an official clarification was sought by Arcadia from Utopia with regards to these diversion projects. So after we found out through satellite analysis, we immediately approached, we asked for a formal clarification from Utopia. And Utopia's response to the same, as given in the facts, were that these diversion projects were temporary and were aimed to replenish the severely depleted reservoirs of Utopia, and these diverted an additional flow of the water from the western rivers. So this is with regards to your second question. Thirdly, the multilateral treaties that were cited by us during the course of our arguments were to just point out the international discourse with regards to the obligations of a party in a treaty, and how, and in through the same pointing out, we tried to point out that Utopia has violated all of these. So the most important treaty that this honorable tribunal has to consider is the Sapphire Waters Treaty. But however, as per the agreement to arbitrate, the tribunal can also consider other treaties to which both countries are a party, customary international law and general principles of law, which was why from the treaty and the neutral experts report, we've also further cited these judgments. Now,
so just to stop you there.
Yes.
So again, I think now a few of us have asked you this question.
Yes.
The multilateral treaty, you have to explain. So you've given us the sources of law that apply here. So under which category does it fall here? Number one. And you have to deal with how VCLT also deals with these treaties. So when there is a multilateral treaty, and which in fact both the parties are not a member to. So what is the value of that treaty in even interpreting this bilateral treaty, and how is that a source of law? Under which category does it fall? And also, you in your introduction, counsel, you said that there is a damages that you're seeking because there is a violation of the treaty. Yes. But on the other hand, your other counsel has submitted that there is a potential violation of the treaty. So we want, and I think that is what the arbitrators, my co-arbitrators, are asking you to understand whether it's a potential violation that you're alleging, or is it that there is an actual violation of the treaty that has occurred. And thirdly, there is already a finding by the neutral expert. How far is that report binding on us? The fact finding that's there, is it binding on this tribunal? Can you please answer that?
Yes. Yes, Mr. Arbitrator, I'll try to answer all of your questions. So firstly, the multilateral treaties that were cited by us during the course of our arguments, they do not particularly bind both of the countries. So which means that we do not have to follow the obligations set forth by these multilateral treaties, since we're not signatories to it. The council would like to, if the tribunal permits, the council would like to put these multilateral treaties in the ambit of the customary international law, because it has a level of acceptance in the water courses treaty, although not signed by both Utopia and Arcadia, it is signed by 30 other nations. So which means it has some level of acceptance in the international forum. So the other multilateral treaties cited could all be placed under the ambit of the customary international law. Firstly, secondly, the council as mentioned again, the council cited these treaties to point out the obligations that are generally envisaged in the international forum, and how Utopia has not fallen in line with these obligations. Now, thirdly, the neutral experts report is binding on this court of arbitration as well as the parties, because as per clause 11 of annexure F of the treaty states very unequivocally that the decision of the neutral expert on all matters within his competence shall be final and binding with respect upon the parties and upon any court of arbitration. So which means, as cited by my co-counsel in the beginning of her submissions, the neutral experts report can and is binding on this court of arbitration and both the parties. And to answer the other question, that is whether there is a potential harm or there is a potential violation, the council would like to make.
Where are you deriving this? Where it says that it's binding on the
I mean,
court of arbitration?
Mr. Counsel,
Yes.
did you just say that amicus curiae report is binding on the arbitrators?
Yes, it is not an amicus curiae report. To my knowledge, it is the neutral experts report. And the paragraph that is being highlighted here is taken from the Zephyr Waters Treaty, which clearly points out that this treaty is binding on this court of arbitration as well as the parties. So it is clearly given. If the arbitrators want the exact document, the exact Zephyr Waters Treaty could also be pointed out. My researcher shall present it in a few seconds. Sorry for the inconvenience caused. So to answer the other question, that is whether there is a potential violation of the treaty or harm. Oh yes, the return report is there. We're really sorry for the confusion. The clause 11 is shared before the honorable tribunal, and it states very unequivocally that the decision of the neutral expert is binding on this court of arbitration. Now, is the tribunal clear? Is the tribunal satisfied on this regard? Can the council move on to answer the other questions posed by this tribunal?
Please go ahead.
Yes. So coming back to the major question, that is whether there's a potential violation of the treaty and harm. The council establishes very firmly that the treaty has been clearly violated. There is no potential violation of the treaty per se. The treaty has been violated. We strongly contend, Arcadia strongly contends here that the treaty has been violated. Now, with respect to harm, since Utopia did not provide us with data when we asked for a clarification with regards to these projects, we are not able to conclusively provide this tribunal with evidence to establish this harm. Because the diversions were made on the sovereign territory of Utopia, Arcadia could not inspect by itself the diversions and what impact it could cause. Now, we have to solely rely upon the neutral experts report to establish the harm. Now, secondly, since there's a precarious situation of drought, the natural flow of these western as well as eastern rivers has considerably reduced, which has led to consequences in both of these nations, which is also clearly established in the facts. Now, since already the flow of the western rivers is reduced, and Arcadia being a country heavily reliant on the western rivers, any diversion that is made by Utopia on its sovereign territory to replenish its reservoirs, although yes, agreeing that it has an obligation to its citizens, it has to make sure that its citizens' rights are also protected and all of that. The facts established that it was not the normal flow of water that was diverted. The flow of water diverted was an additional water flow. Now it is up to this tribunal to give us a conclusion of whether that diversion was correct or not. But Arcadia contends here that even this additional flow of water could have helped Arcadia in its heavy precarious situation, and as pointed out in the treaty, Arcadia is, has a right to receive waters of the western rivers other than the uses mentioned, that is domestic, non-consumptive, generation of hydroelectric and irrigation and agricultural use. So
Sorry,
other than, yes.
So just to bring us back to our award that we are supposed to write based on these submissions.
Yes.
So we have still not heard what remedy we can issue. And from your now additional explanations, it seems you are seeking from us to say that this diversion was not rightfully established, so that to tell a sovereign state what it can and cannot do with its rivers. And second, based on a hypothetical harm, to deprive the citizens of another sovereign country of their additional water flow. So our question is, again, how do we put this in an award? What kind of remedy are you seeking, which we are able to grant as a tribunal, not based on what you think is right or wrong?
Yes.
What is it you are seeking from us at this point?
Yes, Lady Arbitrator. Yes, I'll try to answer this very succinctly. Firstly, we asked this honorable tribunal to either ask Utopia to stop the constructions on these these diversions, or halt the diversion projects, or if that is not possible, a sum of damages should be paid to us in order to ensure that we are adequately compensated for the violation of the treaty as well as the harm that is caused to us.
But again, the violation of the treaty itself does not trigger compensation. There are many cases where tribunals have found states liable of different acts, but have not awarded any compensation to the opposing side because there is nothing to compensate. So what is it exactly that we can compensate in this case?
Well, since Arcadia does not receive the waters from the western rivers, and moreover these diversion projects could also reduce the amount of water, the citizens of Arcadia would be definitely suffering an acute shortage of water. So the amount of compensation that, if this tribunal sees fit to be given, would allow Arcadia to find other sources of water, or other ways to ensure that water is given to the citizens that are in the on the banks of the western river. So,
and has Arcadia offered any such alternative solutions you are now mentioning to Utopia as a preliminary solution? Do we have anything on the record where you have already suggested to them and maybe they will be willing to pay directly? Why does this tribunal have to now intermediate for this kind of solution if you already have ideas which could then protect your citizens? That's also an obligation of your client state.
Yes, Lady Arbitrator. The council cannot exactly point out any material evidence to show that these topics were brought up. But however, there were intense negotiations between the nations prior to this tribunal being established, and during the course of those negotiations, this point could have come up. And since those negotiations failed, we are again bringing up this point in front of this honorable tribunal. So does that answer your question, Lady Arbitrator? Right. If there are no further questions, could my co-counsel continue with her submissions? I think she's reached the penultimate point of her arguments. Yes.
Yeah, sure.
Yes, thank you, Mr. Arbitrator.
Dear speaker, you have 2 more minutes.
Yes, moderate. So lastly, if harm is established, what would be the appropriate reparations is the final issue. So it's submitted before the arbitral tribunal that Arcadia suffers harm based on the potential impact the diversion project may cause to Arcadia. So here the innocent party, which is Arcadia, in addition to its right to regard the treaty as continuing in force, as between it and the party committing the breach, has also a right to demand and receive full reparation for any damage which it may have suffered as a result of such commission of the breach. Highlighting the Chorzo factory case, the court reiterated that principle, adding that it was a general conception of law that reparation must, as far as possible, wipe out all the consequences of the illegal act and re-establish the situation which would in all probability have existed if that act had not been committed. In this particular case, that might not be possible. So a payment of sum corresponding to the value which a restitution in kind would bear, they award if need be of damages for loss sustained, which would not be covered by restitution in kind or payment in place of it. Such are the principles that would serve to determine the amount of compensation due for an act which is contrary to international law. Therefore, Arcadia strongly contends that either halt the construction of the diversion project, either to the findings of the neutral expert report, and make changes to the diversion project and make sure that the water is not restricted to Arcadia, and pay a sum of money as damages as well. Hence, Arcadia submits that Utopia must provide us with these reparations. If the tribunal does not have any further questions, I'll be moving on with the prayer. Wherefore, in the lights of facts stated, issues raised, arguments advanced, may the Honorable Tribunal be pleased to adjudge that Utopia has violated the Zephyr's Water Treaty, and hence Arcadia must receive remedial measures for the same. Secondly, adjudge that Arcadia has suffered harm, and hence appropriate reparations has to be given. Thank you.
Respected tribunals, do we have the permission that respondents will start?
Yes.
Thank you, sir.
Am I audible, moderator?
Not very clear.
Not really.
All right. Now?
Yes, you are.
Yeah. Thank you. The council seeks permission to address arbitrators collectively as the tribunal. May we have that permission?
Yes.
Much obliged. A very good evening to the members of the tribunal. A warm welcome to my co-counsel and learned opposing counsels in today's proceeding. I am Khushi Goyal, along with my co-counsel, Mr. Parth Tyagi, representing Utopia in the present case of Arcadia versus Utopia. Tribunal, may we seek permission to present the relevant documents on the screen? May we have that permission?
Yes, please.
Much obliged. The council representing Utopia would like to first state the summary of dispute. The present dispute is between the two neighboring nations, that is Utopia and Arcadia. Both nations share the same river system, that is Zephyr River system, which is crucial for both. In 1960, they entered into Zephyr Water Treaty that divides the river system into two groups, Eastern River System and Western River System. Eastern River System are allocated to Utopia and Western River System allocated to Arcadia. Now the dispute is over the Western River System, which are allocated to Arcadia. That arose in the spring of 2023 due to the reduction of water level owing to severe drought, causing socio-economic distress among Utopian population. As a consequence of a severe drought, Utopia constructed a series of temporary diversion channel on Western River to divert the water just in order to provide an immediate relief to its citizens. And this construction was objected by the Arcadia and demanded the clarifications from Utopia's Act. In furtherance of this, the Permanent Zephyr Commission inspection was done, and further the neutral expert was appointed in this regard, where both have highlighted that the project are of temporary nature and is constructed due to the urgency of the matter, just to tackle the severe drought conditions and the water distress. Then in early 2026, after an impasse in the negotiation, we agreed to the request of Arcadia and entered into the agreement to arbitrate on 1st November 2027. The aim of this court of arbitration is to resolve this issue.
You say that it's a temporary construction. When
Yes.
was the construction done?
In the spring of 2023, when the drought was hit to the Utopia.
And what's the year when this arbitration is happening?
In 2027.
So 4 years have passed. So what do you
Yes.
mean by temporary?
So as we all know that the Zephyr River system is a huge basin in the world. And the temporary, it should means that the temporary nature of the project should be 15 to 20 years only.
Where are you getting this definition from of temporary being 15 to 20 years? Is it based on some text of a jurist or some kind of an expert in this area?
Thank you, Sir Arbitrator, for the question. The text can be derived from our experts that have been done in the territory of Utopia. That's why we are stating that the temporary, and by the general interpretation also, if we are doing the construction work on such a huge basin of a river, then it must be a 15 to 20 years only.
Also, the speaker number 2 would like to seek the permission of Mr. Arbitrator to add to the contentions of the speaker number 1. Do we have the permission?
Yeah, please.
Yeah, much obliged, sir. Sir, so the whole aim of constructing the diversion projects were to replenish the extremely depleted water reservoirs of Utopia. So the projects were made with the projects were engineered in such a manner to replenish the reservoirs as soon as possible, and as soon as we achieve that aim, the projects will be uninstalled, as also highlighted in the neutral expert report.
Please go ahead. Please go ahead.
Thank you, Sir Arbitrator. The aim of the Court of Arbitration is to resolve this issue, to promote the good neighborliness and our general duty to cooperate. Here, with the permission of the tribunal, in the present case, we would like to highlight mainly 3 issues as per the page number 10 of the Moot proposition. May we have the permission?
Yes.
Much obliged. Firstly, whether the Utopia's diversion project are in violation of the treaty. This issue will be dealt by speaker number 1, and the other 2 issues regarding the appropriate remedial measures and reparations, if the violation is found, will be dealt by my co-counsel, Mr. Tyagi. With the permission of the Honorable Tribunal, I, as a first speaker, will reserve next 7 minutes, will reserve next 11 minutes to submit that Utopia's diversion project are not in violation of Zephyr Waters Treaty. May we have that permission?
Yes.
Much obliged. It is our submission that the said diversion project had not violated any obligation under the Zephyr Waters Treaty, and we have adhered to the Pacta Sunt Servanda principle and Article 31 in compliance with 32 of the applicable convention, Vienna Convention on the Law of Treaties, which states when the interpretation is done, it should be done in a reasonable manner and should not leave any ambiguity. Moreover, as a party to a treaty, Utopia has fulfilled all the agreed obligations. In order to substantiate the same, firstly, the council would like to bring the attention of this honorable tribunal that the claimant in their argument has failed to explain any detrimental effect as a result of the projects. From early 2024, that is, since day 1, claimant has failed to explain any potential effect of the projects. The claimant has always used the word could and has always highlighted that it could impact, which explicitly means something in future, but not anything in present, which has caused harm.
Sorry, Counsel, do we need an actual impact to determine a violation of the treaty? We heard from the counsel of the opposing side that there was a duty at least to notify in good collaboration based on the applicable treaty between the 2 countries of such measures that might have an impact. So even if you were to proceed urgently with this measure in the public interest, wasn't there also a duty to notify and to extend this information to the other side?
Thank you, Madam Arbitrator, for the question. Indeed, no arbitrator, we are not obliged as per the applicable treaty. Moreover, my friend has highlighted in the argument about Article 7, Clause 2, but have failed to add the proviso provision of the applicable treaty, that is the Zephyr Waters Treaty. And as per the Spain versus France, the relevant case law in this case, where the tribunal found that there is no violation of the treaty, because here in this case, the Spain, which was the claimant, had failed to explain the detrimental effect as a result of the respondent's project. So hence, taking this case into consideration, and the case which is persuasive in nature, we say that it is not a violation.
The speaker number 2 would again like to highlight and add to the contention of the speaker number 1 if the Madam Arbitrator agrees. Ma'am, do you have the permission? Much of that. So, ma'am, as per the question, have we violated the treaty? Yes, as highlighted by the speaker number 1 of the team representing Utopia, have highlighted Article 7, Clause 2. And as highlighted by my co-counsel as well, that Article 7, Clause 2 proviso talks that if the party constructing a project is of the opinion that it would not cause any harm or any significant harm to the other party, then it is not necessary for the constructing party to notify the other party. Now, it is not just our opinion. Our opinion is also substantiated by the findings of the Permanent Zephyr Commission, as well as the binding report of the neutral expert. So it is not just our opinion, but we have also the scientific evidence to back up our arguments.
Counsel, sorry, if I could just interject, could you just clarify there is a distinction between harm and serious harm?
Yes, sir. Indeed. Thank you so much. Thank you, sir, arbitrator. So the difference between harm and significant harm is outlined under the UN Watercourse Convention, where Article 7 explicitly talks about what constitutes to a significant harm. Now, in order to prove a significant harm, the party claiming the harm must provide evidence and scientific evidence, as well as reports to back their claim, that they have to quantify their injury. And as per the agreement to arbitrate, the said treaty is also applicable law in our present case. So the mere difference, and also as per the page 13 of the Moot preposition, the neutral expert clearly highlights that the projects are created in such a way that it does not create a significant harm in the as per the treaty, as per the agreement to arbitrate.
So let me just see if I've got this clear. Your contention, as I understand it, is that the treaty only works in a reactive way, i.e. once damage has occurred. Let's assume with significant harm, there's no basis for being preemptive to avoid that very harm that may occur later. Is that correct?
Indeed, arbitrator, sir, no, but in order to get the preventive measures from the honorable tribunal, the councils must provide for the reasonable grounds for seeking that prevention, which the councils have failed to provide without any scientific evidence or any backup. So,
but that's forgive me for interrupting. That's an important distinction. So you're not saying it's limited to a situation where damage has occurred. It is possible to implement the terms of the treaty to avoid damage, but obviously your position is the other side has failed to provide us with the necessary evidence that there may well be damage that would be incurred if we were not to intervene.
So as per the Annexure 2, page number 17 of the Moot preposition, the findings of the binding report of the neutral expert clearly states that both projects have been designed with safeguards aiming to minimize the environmental effect and to adhere with the principle of the Zephyr Waters Treaty. Now, that clearly shows that we have clearly have been in consonance with the treaty as well as the principles of the international law, as well as aiming, not just aiming, but successfully have implemented those projects in such a way that it does not cause any environmental harm or any significant harm whatsoever to the other party. And the other party claiming the remedies has no grounds to provide a ground for it.
Yes, but that just refers to economic impact. Environmental impact.
Yes, sir.
I mean,
sir,
the damage could be wider than environmental impact, could it not, in terms of economic impact?
Absolutely, sir. Totally agree. But in order for the monetary compensation to be granted, it requires a proof of direct, substantial, and quantifiable injury resulting from the alleged wrongdoing, which is also highlighted in the Barcelona traction case. And the councils representing Utopia failed to mention any substantial, any quantifiable, or any direct harm between our alleged wrongdoing or our alleged wrongdoing and the harm caused.
Yes, sorry, with this, just to come back, and I'll end with how I started, because I think that's what it's understanding that it's what they have failed to show, that there has been actual damage. Let's accept that for the purposes of our understanding for the moment, but it wouldn't prevent them seeking relief from the tribunal if they could show there would be damage. Is that correct? So it's an anticipatory relief as opposed to a relief as a result of damage having been caused.
Indeed, arbitrator, but no, as also highlighted the precedent, the Chorzo factory case, it highlights that the party claiming the damages, the preventive measures, if not the compensation, the preventive measures, they need to establish a direct causal link between the harm and the actions, which again, the council have failed to provide. So not just the compensation. Okay, much obliged.
Thank you.
If I may here, as far as the finding, so I think it's agreed that the neutral expert findings are binding. So if you agree to that, then if you see 3.1 of the finding of the neutral expert, clearly the finding is that the Poseidon irrigation scheme has limited provision for returning the water back to the river. Secondly, in 3.2, the neutral expert has found that the Neptune hydroelectric project could influence the timing and intensity of the flows. So these are binding on you as well. And it's clear that there is an impact on the flow of the water. There is a finding of the neutral expert. So on what basis is it that you claim that there is no finding at all?
Thank you, Mr. Arbitrator, for the question. Indeed, we are taking 3.1 and 3.2 into consideration as per the annexure 2 of the neutral export. About the Poseidon irrigation scheme, we may use the water for irrigation purpose as per the exceptions in Article 3 of the applicable treaty, that is the Fire Waters Treaty. The exception states the first exception in this regard is domestic use, second, non-consumptive use, third, agricultural use, and fourth is generation of hydroelectric power. And here in the present case, we are using the water for these purposes only. This simply means that we are not violating the water for the applicable treaty. Again, now in regards to the Neptune hydroelectric project, as the applicable treaty, it is allowed to construct run-off river hydropower project on the river. Here, the run-off river project simply means it will not affect the volume of water. And regarding the timing and intensity of the flow, it has been highlighted by my learned opposing counsel.
Also adding to that, adding to the contentions put forth by my co-counsel, sir, as per the page 6 of the Moot preposition, it clearly states that the diversion projects were on the additional flow, were constructed on the additional flow and not the main flow of the river. Hence, the contention put forth by the council representing Arcadia that we have damaged the flow, damaged their water flow is baseless. Because it is a statement of fact, it is mentioned in the statement of the fact that we have constructed the project on the additional flow of the river and not the main flow of the river.
But clearly there is a finding by the neutral expert that it does affect the flow of the river. Does the treaty distinguish between main flow and additional flow? Is there a distinction in the treaty? Number one. And number two, when there is a finding of the neutral expert that there is diversion, there is an effect of the flow, how is it that you continue to claim that there is no impact when it is agreed that we are all bound by this neutral expert's report?
If the arbitrator
in fact, the neutral expert has gone on to give recommendations. If there is no harm and no impact at all, why would the neutral expert have given any recommendation at all?
Indeed, Sir Arbitrator, but no, the neutral expert himself used the word could impact the additional flow. And as per the limited provision for returning back of the water, it does not hamper the right of Arcadia, which they are alleging that we have violated through the treaty provision. And as per 3.3, the findings of the neutral report, it clearly states that we have adhered to the principles of the Zephyr Waters Treaty. Hence, they have no evidence that their flow is being, any scientific evidence that their flow is being breached by us.
Where is the distinction of new main flow and additional flow in the treaty?
So there is no distinction between the additional flow and the main flow of the river. But as the general connotation of the word additional and the main flow, it clearly states that if you are constructing a project on an additional flow of the river, it certainly will not impact on the main flow.
Clearly, the use of the treaty is bound by Annexure C and D to the treaty, which restricts the units of your water that can be used. So it is not that you have an unlimited use of the water as far as irrigation or even hydroelectricity is concerned. It's bound by Annexure C and D. So can you establish that it falls within the boundaries of Annexure C and D to the treaty?
Thank you, Sir Arbitrator, for the question. For this, the speaker number 1 will like to highlight that as per the Annexure D, just give me a second. So, yeah. Annexure D, paragraph 15, clause 3, which highlights the phrase if necessary. The term necessary by a general interpretation as per Article 32 of the Vienna Convention means anything which needs an immediate action. And here the severe drought creates a situation which needs an immediate action, which the Utopia did. Also, it is to bring the attention of the Honorable Tribunal.
So the drought required you to have an hydroelectric project. I can understand that the drought required you to have an irrigation project. But how did the drought mandate that you have a hydroelectric project?
So, thank you for the question again. The Neptune hydroelectric project, which is the project of Utopia, is a runoff river project. And it is allowed as per the applicable treaty.
Please go ahead.
I just wonder if I may, because it was something that Mr. Tyagi, I think, mentioned. He referred to the principles of the treaty. And one thing I just wanted to try and get some guidance from Council is to what extent we are supposed, regardless of what the actual provisions say, principles kind of, I think, occupy a level above, that floats over it, if you like. And in terms of the spirit of the treaty, is it fair to say that even if one complies with the strict terms of the treaty, one may not actually be complying with the principle or spirit of the treaty? I wonder if you can give us some guidance on that, please.
Yes, sir. Yes, thank you, Sir Arbitrator. Indeed, as highlighted by Mr. Arbitrator, that yes, the principles also lay a groundwork for the implementation of the treaty. Yes. But as highlighted as the speaker number 1 and 2, that about the good neighborly concept, as mentioned in the preamble of the treaty, it is a general principle in the international law as well as the preamble of the applicable treaty, which so examples like Lake Lano arbitration case and the Hungary versus Slovakia case demonstrate how this principle has effectively resolved water disputes. Now, sir, in cases where unforeseeable circumstances like drought impact treaty performances, parties are expected to engage in good faith negotiations, and which we have demonstrated time and time again, as also mentioned in the statement of the fact that both the neighboring countries, have had several political and military standoffs. Yet the treaty is a beacon of success and withstood the test of time. So I think both the nations have successfully followed the principles of the treaty. If the speaker has satisfied Mr. Arbitrator, then we can move forward with the arguments, or if there are any questions left.
I'm not sure it does actually answer my question specifically, but I'm conscious of time, so I'm happy to accept the answer and move on.
Much obliged.
Thank you, Tribunal. Now, further in regards to the provisions of the treaty, the Council seeks permission to highlight the relevant provisions of the applicable treaty one by one. May we have the permission? Much obliged. Firstly, Article 1, Clause 15 defines the term interference of water, and its subclause B states temporary bypass as its exception. Neptune, the respondents project, that is Neptune hydroelectric project and Poseidon irrigation scheme on the Western River, are temporary nature and was constructed due to the urgency of the situation, as firmly stated in the inspection conducted by under the supervision of Permanent Fire Commission, page number 7 of the statement of facts, and also the neutral expert report, Annexure 2, page number 17, clause 3. This is also indeed recognized in the case of Hungary versus Slovakia of 1997, where International Court of Justice held that temporary obstruction of a river in necessary situation would not necessarily constitute a violation of a treaty. Therefore, temporary obstruction of a river is not a violation of this treaty as per this article and referring to this case. Further, the Council acknowledges the claimant's right over the Western River as per Article 3, but the Clause 2 of this article explicitly states 4 exceptions, as the Council has already stated in front of the tribunal. First is domestic use, second non-consumptive use, third agricultural use, and fourth generation of hydroelectric power. And here, in the present case, we only use the water for these purposes only. That simply means that we are not violating the applicable treaty. Now, the claimant has repeatedly stated that Article 4, which states the obligation of the party to use their best endeavors to maintain the natural channels of the river. We would like to bring the attention of my learned opposing counsel that we are obliged to this treaty and have always used our best endeavors, even during the geopolitical changes, previous several crises between the two nations. Also, in the 2007, when Arcadia raised the issue of the Balehar project, named BHEP, which also in compliance with the Zephyr Waters Treaty and the neutral report, even then the Utopia halted the project in relation to the to promote the good neighborliness and to foster cooperation, as the preamble of the applicable treaty states. Because at that time, there was no emergency, but now in the present case, there is a severe unprecedented drought, and the condition is such that we need to safeguard our citizens. Therefore, taking severe drought conditions taking into consideration, the project were a necessary response and were in line with the treaty's provision, allowing the respondent to utilize the Western River within the territory under exceptional circumstances. As the Council number 1 has already highlighted in the Court of Arbitration, this exceptional circumstances is defined under Annexure D, paragraph 15, clause 3 of the applicable treaty, which highlights the term if necessary. Also, we would like to bring the attention of this honorable court that the drought impact not only depend on severity, intensity, and frequency, but also the generated demands of the humans on the regional supply of water. Therefore, drought risk is a combination of drought hazard and drought vulnerability. My learned friends in this case, in their summation, have highlighted that we have not communicated about the project to the claimant and about the 3.1 and 3.2 findings of the neutral expert of Annexure 2. For that, we would like to bring their attention that firstly, we are not obliged as per the Article 7, Clause 2 of the applicable treaty, which states that the one party is not only under the obligation to notify the other party about their project if it is in their opinion that the project would not affect the other party. Secondly, the project is of temporary nature and constructed due to the urgency of the matter. As stated, the nature of the project is temporary. So as soon as our depleted reservoir is replenished, the project will be uninstalled. To explain this more, as the tribunal may also see on the screen, the simplified sketch of the reservoir that we are utilizing the water to fulfill the conservation zone. As the tribunal may also see on the screen, the simplified sketch, not exceeding more than that. And for a bare minimum substance of the our citizens, we are doing that. Thirdly, regarding the claimant submission on the findings of the neutral expert on Annexure 2, page number 17, about the Poseidon irrigation scheme, we use the water for the irrigation
Is this
purpose.
diagram present in the Moot proposition?
So this sketch,
Yes.
no, sir. About the Poseidon irrigation scheme, we may use the water for irrigation purpose as the exceptions in Article 3 without the permission of the provision of the returning back to the water. Secondly, about the Neptune hydroelectric project, as per the applicable treaty, is it allowed to construct run-off river hydroelectric projects of the river? Here, the run-off river project simply means it will not affect the volume of the water. Here, the question arises is that how can the claimant quantify the same as there is no effect on them? Therefore, I rest by saying the utopia, that is respondent, has not violated the applicable treaty. Now, I request the Honorable Tribunal to allow my co-counsel to enlighten us on issue number 2 and issue number 3 on remedies and reparations in this case.
Sorry, Counsel, but just to reiterate, so because there is no quantifiable damage, there cannot be any violation. That's your contention to us. So we cannot find a violation of the treaty on your side unless we can quantify damage.
Madam Arbitrator, the speaker number 2 would like to take the question if the permission is granted.
Yeah, sure.
Much obliged, Madam Arbitrator. As also highlighted previously by the speaker number 2, ma'am, there need to exist a direct causal link between the alleged harm and our actions, which the claimant has failed to establish. Hence, there cannot be any preventive measures granted. Now, had they
No, again, harm, do we need harm to violate this treaty? Because it seems to be a treaty on collaboration. It seems much more than specific duties to act or not act. So is the only way for us to find a violation of this treaty if there is a real harm and if there is quantifiable damage?
It is a request to Madam Arbitrator to kindly state the question again, as the council failed to understand the question.
No, just similar to your colleague. So is the only way for your country to breach this treaty if there is a harm that's determined or if there's quantifiable damage? So there's no way to violate this treaty otherwise, just to clarify.
No, ma'am. As per all the treaty provisions highlighted by the opposing counsel, in regards to the treaty violation, we have clearly established that there has been no treaty violation in this regard.
Okay, you can proceed in the interest of time. Thank you.
Much obliged. Thank you, co-counsel, and greetings to all the members of the tribunal and the learned opposing counsel in today's proceedings. I'm Partyagi, the second speaker representing our case, and I would like to reserve 14 minutes for my submissions, where I shall address the second and the third issues. Now, as submitted by my co-counsel earlier, that we have established that there has been no breach of the treaty violations on our part, as per Article 1, Clause 15, Article 3, Article 7 of the applicable treaty. Now, with the permission of the Honorable Tribunal, the Council would like to contend that Arcadia is not entitled to any sought remedies, followed by our request for appropriate measures as sought as remedies. Do we have the permission to proceed? Much obliged. So, as rightly mentioned by Angela Merkel, that climate change knows no borders. The whole of international community has to shoulder a responsibility to bring about a sustainable change to the problem. Now, the primary contention that the Council would like to put forth before this Honorable Tribunal is that the remedies requested by Arcadia are not justified in the light of our arguments against them. So firstly, the treaty provisions as outlined under Article 6, 7, 9, and other customary international law on the shared water resources are enough to cite that there does not exist a prior consent does not exist a need for taking prior consent or notification that is required for the development projects pertaining to the current facts of our case. Now, for the monetary compensation to be granted, as previously highlighted, it requires a proof of direct, substantial, and quantifiable injury resulting from the alleged wrongdoing, as indicated by the precedents of Barcelona traction case and sovereignty over Pulau litigant and Pulau Sipandan case. The councils representing Utopia have also, Arcadia have also highlighted the trace metal arbitration case. But then again, that case is not justified in the present case since the arbitration awarded the compensation for damages caused by the cross-border pollution, which was also recognized by the speaker number 2 from the claimant side. So that we contend that Arcadia has not suffered such damages as to warrant compensation under this precedent. Also, the pulp mills case on River Uruguay was highlighted by speaker number 2. And while this case encouraged good faith negotiations and cooperative solutions to environmental disputes as per paragraph 131, and the respondent contends that this precedent supports respondents' approach to consultation and negotiation rather than the prior consent. Even the Danube case mentioned by the speaker number 1, the precedent is not applicable since the compendium stated that change in the course of river. But in this regard, this is not applicable since there is no alternation in the flow of in the main flow of the river, which has also been substantiated by the neutral report. It is also imperative for the council to highlight the claims for any injunction made by the claimant since they lack merit in its entirety. As per the Danube Dam case, it states that parties may seek an injunction when they can demonstrate that the other party is violating international treaties or agreements related to the use and management of the water resources as per paragraph 31, which the claimant has failed to establish. Also, it is essential for the party to highlight potentially irreversible and quantifiable damage as per the case of Hungary versus Slovakia, which the other side has also highlighted in their submissions and has failed to establish in our current case, which was also highlighted by Mr. Shravan and Mr. Mahadevan sir, Mahavendra sir. Sorry for the mispronunciation of the name, sir. Much apologies. So our fundamental ground for seeking one fundamental ground for seeking the injunction is to prevent imminent and irreparable harm to the water resources. Now, this principle is supported by the precedent, which was also highlighted by the opposing counsel, which is the Hungary versus Slovakia case in the paragraph 78. But they have not been able to substantiate their grounds with enough evidence and enough scientific evidence. Now, speaker number 1 has also stated that they strongly contend that we have not obliged the general duty to cooperate. Now, the customary international law specifically talked in the North Sea continental shelf case, it emphasizes that states have a general duty to cooperate in the management and utilization of the shared resources. Now, we argue that this duty does not inherently require prior consent or for the development project that we need to adhere to. And as far as speaker number 2 highlighted the need for restoration, as per the Chorzo factory case, the said precedent is not applicable in our present case since it talks about the international principles related to the protection of foreign property and the rights of foreign nationals in the host states. Hence, it does not match the current facts of our present case. So therefore, we submit that Arcadia is not entitled to any remedies as there has been no breach of the treaty, nor any violation of thereunder. So therefore, the remedies sought by Arcadia, including compensation, injunction, restitution, amongst others, are not justified based on the legal and the factual circumstances presented. Now, coming to the remedies that we are seeking, that we found to be just in our present case, is the first declaration of no breach, which is an appropriate course of action to address the dispute between both the parties in the cases of international breaches of the treaty. So our proposal for this remedy is it seeks to address the fundamental fact and issue of us not violating any obligation. As Article 1, Clause 15 clearly states what constitutes to interference with waters, and it states that any temporary bypass construction does not amount to temporary construction, does not amount to any violation or any interference with waters. So this is the common remedy which is used to clarify the legal status of the parties' actions and the obligations arising out of the treaty. Another measure that we would like to highlight is the principle of good neighborliness, which we already covered in the cases of Lake Lano arbitration and the Hungary versus Slovakia case. Now,
Council, sorry, just a very quick question. It's come up before, but this question of temporary, would you say the provision you've just referred us to that would contemplate a period of 15 to 20 years that we were originally told would indeed could indeed satisfy the definition of temporary?
Sir, thank you so much, Sir Arbitrator. Now, to answer the question posed to us, our aim to install such diversion channels was to replenish the depleted reservoirs, which is an essential feature of the river Indus Basin, River Zephyr Basin. Now, in order to that to happen, we engineered the project in such a way that it not only minimizes the impact on Arcadia, but also replenishes the depleted reservoirs as soon as possible. And as soon as we achieve that aim, the project will be uninstalled.
So if that aim takes 15 to 20 years, that satisfies the definition of temporary in your submission?
Yes, Sir Arbitrator.
Okay, thank you.
So in the light of the arguments advanced, we firmly state that Arcadia's requested remedies lacked merit as well as our entitlement to the remedies stated. So to this end, we draw upon the precedents in the international law and the arbitral jurisprudence. Now, with the permission of the Honorable Tribunal, the Council would like to discuss that Arcadia has not experienced any damages from our projects, followed by our right to receive reparations in the present case. Do we have the permission? Much obliged. Now, this contention will examine the applicability of the no significant harm rule under the UN Convention, UN Watercourse Convention, and the customary international law to determine that whether our actions constitute a violation or not. Now, Article 7 of the Convention explicitly emphasizes the need to prevent significant harm to other riparian states. Now, to answer the question by Sir Arbitrator, which was posed to us, that as per paragraph 192 of the pulp mills case, harm caused cannot be the sole factor for Article 7 to be invoked. Now, it is rather determined by the country's reasonable conduct in terms of preventive behavior to avoid the harm in question. Now, our claim is also substantiated by both the reports. One is of the persuasive value, one is of the binding value, that we have taken all the preventive measures in our due diligence, supporting our due diligence. Precedents such as Hungary versus Slovakia have also consistently upheld this principle in the international water disputes. Now, the burden of proof rests with Arcadia to demonstrate that Utopia's construction has indeed caused significant harm, which they have failed to achieve. And to substantiate their claim, Arcadia must provide credible scientific evidence to establish a clear causal link between the harm alleged and our actions. Since the claimant has also highlighted the principle of reasonable and equitable utilization as per Article 5 of the applicable convention, now while highlighting that application, that the application of this principle is based on the different
Council, we'd ask this question to the other side as well. This is a multilateral convention which we understand both the states are not parties to. So how far can you rely on this treaty? And how can you use this to interpret your bilateral agreement in the context of the Vienna Convention of the Law of Treaties?
Thank you, Mr. Arbitrator, for posing the question. Indeed, no, the council representing Arcadia has misled the tribunal, since as per page 13, which states the relevant legal principles and authorities, point 2 clearly states that what sources can be used in the international water law. And it says the United Nations Convention on the Law of Non-Navigation Uses in International Water Convention, which is the present convention that we have just stated. It is an applicable source of law. Also, as per the agreement to arbitrate, it substantiates our claims furthermore.
I think you misunderstood the query, Council. You're referring to it. So the first question is, are you a party to that convention?
Yes, sir. Since it is an applicable law, both the parties are signatories and ratified the convention as per the applicable
Where
law.
do you find this in the Moot proposition?
Sir, page number 13, point number 2.
It just talks about principles of international water law. It doesn't say that you're a party to that convention.
Sir, it states the relevant legal principles and authorities that can be used in our present case.
Indeed, but does it say that you're a party to that convention?
Sir, it is a fact mentioned in the Moot preposition. Now, there is nowhere mentioned, like for example, the point number 1 clearly states the Zephyr Waters Treaty. Now, it goes without saying that both the parties are signatories to the treaty, hence it is mentioned in the relevant authorities.
Please go ahead.
Much obliged, you lot, Sir Arbitrator. Now, since the claimant have also highlighted Article 5, while also highlighting the application of this principle is based on different facts and different circumstances. The respondent states that their actions have been in full compliance with the above principles. Since when we talk about the equitable utilization, now the tribunal, it is imperative for the council to highlight that in 1960, when we signed the treaty, we knew that we were going to be at a disadvantage considering the total volume of the Indus River, the Zephyr River system is of 16 crore acre feet, out of which we were only allotted 3.3 crore acre feet, and out of which we only consume 3.1 crore acre feet. Now, we understand the principle of equitable utilization, considering that Arcadia's population is more heavily reliant. Henceforth, we agree to the such division of the waters. And as far as the principle of reasonable utilization goes, Article 6 clearly states the grounds for what constitutes to Article 5, which Clause 1, Subclause A, clearly states the words other factors of natural character, which a drought clearly fits into the definition. Now, as per the UNDRR report of 2021, the impact of drought on the utopian economy and the GDP is to be 2 to 5% per annum. Also, the Global Assessment Report on Drought 2021 affirmed the UNDRR study that about 43% of the Deccan landmass is prone to severe desertification. Not just theoretically, but also practically, the Deccan region has seen a 6% of higher frequency in the droughts. So, as a precautionary measure, we constructed a temporary channel in our territory with little to no impact on the Arcadia flow, which has been substantiated by both the Commission's findings and the expert report. Since according to the ICIMD 2019 report, if the climate change persists, the Zephyr Basin will lose 1/3 of its volume. Hence, it was a necessary condition, as also highlighted by the speaker number 1. Now, we suggest that employing an acknowledgement or apology can be a valuable diplomatic tool to foster goodwill and cooperation between both the parties. Now, such gestures have proven to be effective. For example, in the case of Trail Smelter Arbitration and Corfu Channel case. So, in conclusion, Utopia asserts that its actions are in alignment with the interpretation of the treaty as per Article 31 of the VCLT. And given the severity of the drought situation, extending an apology or acknowledgement may serve as a valuable diplomatic tool. And before summarizing the remedies and reparation, it is imperative for the Council to also mention that as per the Ministry of Agriculture, Government of Utopia, 2009 report clearly states that 68% of the land is prone to the varying degrees of droughts. And as per the UNDRR 2021 report, Arcadia needs to understand that the climate change is a global phenomena and not just restricted to its boundaries. About 42% of our cultivable lands fall under the drought-prone areas, as per the report. And every drought causes the poor farmer to recover from its impact in 3 to 4 years, obviously depending upon the intensity. Now, not just that, but in 1991, Arcadia promised its provinces that it would maintain the basic flows, ensuring a 12.3 kilometer cube runoff to preserve fisheries, sediment transportation, and other issues. But in practice, the target has never been met. In fact, the runoff from the Zephyr Delta has been consistently recorded at below 12 kilometer per cube. Now, the satellite imaging has revealed that aquifers dependent on the river basin are losing an average of 10 kilometer cube of groundwater per year. Now, this rate of depletion is equal to the amount of water held by 6 large utopian dams. Hence, Arcadia only has the capacity to store half the total amount of the depletion. So, in the light of the arguments presented, Utopia respectfully contends that Arcadia is not entitled to any remedies in this dispute, as there has been no breach, as it has been repeatedly reiterated by the councils. The treaty and the customary law do not mandate prior consent and notification for the development of the project, and the respondent's action align with the principles of cooperation and reasonable and equitable utilization of the shared water resources. Therefore, I wholeheartedly endorse the submissions put forth by my learned co-counsel, and it is requested to the tribunal to kindly move towards the prayer for relief. Do we have the permission? Much obliged. Firstly, we firmly request the dismissal of Arcadia's claim in their entirety. We believe that these claims lack merit, and our arguments and evidence will substantiate that we have not breached the Zephyr Waters Treaty. Secondly, we seek a declaration from this honorable tribunal that we are indeed in full compliance with the Zephyr Waters Treaty as firmly stated in the findings of the Newton Expert Report in Annexure 2. Thirdly, we urge the tribunal to declare that we are entitled to give any remedies that Arcadia has sought, not to give any remedies that Arcadia has sought. Now, we believe that our prayer for relief aligns with the merits of this case and respectfully request the tribunal's consideration on these points. Thank you.
Yes. So if the tribunal permits, could the council present its rebuttals to the submissions made by the opposing council? Yes, obliged, Ms. Tribunal. So firstly, the councils for Arcadia strongly are firstly surprised that the definition of a temporary diversion project is amounts to the timeline amounts to 15 to 20 years, and we firstly pose the question as to when the aim of Utopia to replenish its reservoirs would get fulfilled, because if you're given such a long timeline, then the harm that Arcadia will have will be much worse. So that is our first submission. Secondly, the opposing counsel repeatedly pointed out that we have to establish that we've faced harm in order to claim damages before this tribunal. Well, we agree that we have to establish, because but we'd like to counter this point by stating that we have asked for a clarification from Utopia with regards to these diversion projects, and we have not received any response to it. During the course of our negotiations, also this point was conclusively pointed out again and again, that there was no data that was shared about the projects that happened here. So in that scenario, how could we establish harm? See, because the projects are happening in the sovereign territory of Utopia. So Arcadia cannot breach the sovereign territory of Utopia to go see the potential impact that these projects could have. So when we approached through diplomatic channels for the data for these projects, Utopia gave us only a plain statement saying that these were temporary and were made to additionally to replenish the depleted reservoirs. Now, thirdly, the opposing counsel pointed out the Lake Lennox clays and stated that they are not under an obligation to consult. We wholeheartedly agree, but the spirit of the treaty is cooperation, and a drought situation that is faced by both countries. In such a scenario, cooperation is more than required in order to ensure that both the countries, weather through this, precarious situation. So in that case, wouldn't a consultation, shouldn't they have consulted us in order to, make sure that their obligations as well as our, objectives both meet and ensure that there's compliance in that regard. So next, yes.
You mentioned about data sharing.
Yes.
I didn't hear you mention this during your opening arguments. Is there any reason for this?
Yes, because clause 2 of Article 7 of the treaty, as pointed out by my learned opposing counsels, the first proviso, if my researcher could, provide the provision to.
It's okay. You can just tell us.
Yes, Mr. Arbitrator. Clause 2 of Article 7 states that if the party constructing the engineering work, in its opinion, feels that the project would materially affect, it can supply the data. And the second proviso, the continuation to the proviso states that if the party asks for data, nevertheless, whether the party planning the data is of the opinion that it would cause damage or not.
My question, Mr. Counsel,
yes,
is why did you not raise this at the outset, this argument?
Yes, apologies, Mr. Arbitrator, but this point was raised in the beginning of my submissions.
Okay.
I apologize if this point was not adequately established by me, but the proviso is here. It said that.
Please continue. Please proceed.
Yes.
Yeah.
Yes, Mr. Abri, I hope I've answered your question.
Yes, you
have. Yes, my question was with regards to this clause. So this point has been raised. So moving on, the neutral experts report states that the projects aim to minimize impact and adhere to the principles. However, the findings of the neutral expert also state that Arcadia and Utopia must enter in negotiations to ensure that these projects are in compliance with the principles of the treaty, which means that there is a confusion as to whether these projects are in compliance with the treaty or not, which this honorable tribunal is to conclusively ascertain whether it is in violation or not. Our contention is that it is in violation of the principles of this treaty. Now, the opposing counsel also mentioned the Chorzo factory case and stated that the facts do not come. The facts of that case does not apply to this case. Yes, we wholeheartedly agree. But the reason why we cited the Chorzo factory case was to point out the general guidelines that arbitral tribunals and international courts must have while awarding reparation. So that was the reason why we cited that case. We are not arguing that case on the merits or on the similarity of facts. Now, the opposing counsel made a blatant mistake by stating that the UN Watercourses Treaty, that Utopia and Arcadia are signatories to the UN Watercourses Treaty. It is nowhere established through the facts of this Moot proposition, as well as in any other manner, that both Utopia and Arcadia are signatories. They are not. The facts also state that the UN Watercourses Treaty could be used as a guide to ensure that to make our points. Basically, that is what the point is. And
you have spent time for the rebuttal that you were advocating.
Yeah, Mr. Counsel, I just want to ask you one thing: is that what is your counter argument to stating that it is temporary in nature? They said 15 years. You haven't explained your argument as to what should be the temporary in nature. Secondly, how is ascertaining the impact in your territory dependent on the data? That itself makes it very speculative in nature. Are you asking for speculative damages from the tribunal?
Yes, Mr. Arbitrator. To first answer your question, if my hearing was right, your first question was with regards to whether the data is, how we establish that harm is caused through the data. Am I correct in stating that?
First is what is your counter argument?
Oh yes.
What
yes.
is
with regards to the temporary usage? Yes.
Second thing is how is your assessment dependent on the data from the respondent? That itself is speculative in nature.
Yes. Yes, Mr. Arbitrator. So firstly, we strongly contend that the timeline that is specified by the opposing counsel, that is whether that the temporary projects are of 15 to 20 years, is first wrong, because we do not find any, again, this was not communicated to us firstly, and secondly, the exact definition as to how many years a temporary diversion project is there is no conclusive definition as well. So we strongly contend that their definition of 15 to 20 years is not right. Because if we give in to this,
if the tribunal said that temporary is 30 years, would you agree to that?
It is a difficult question to answer. We might have to adhere to the findings of this tribunal, but we would cite that they have violated the provisions of international law. If the tribunal states that they have not violated the treaty and these projects are of a temporary measure, we would again contend that they have violated international law, because equitable and reasonable utilization and significant harm, the principles, both of these principles are violated. Now, second,
but just back to the question of the co-arbitrator, I mean, again, it seems as if you are pursuing this claim out of principle because you are offended by the action of the other side, but you first sought information from them to feed into your claim. And when you couldn't find them, you came to the tribunal to substantiate your claim for us to find something that you have not brought before us yet. So again, on the facts, what can we declare in this award as factual and verified as a violation of the treaty?
Yes, Lady Arbitrator. Firstly, as pointed out under clause 2 of Article 7, when our clarification was not responded correctly, that is a clear violation of the treaty, because the material provision is very clear that they have to provide us with data when we ask for it. They've not provided the same, and that is the violation of the treaty that that is one of the violations of the treaty we've contended.
But even if there is no such data to be provided at that moment, because maybe there was really nothing yet to.
But yes, lady arbitrator, you're right. But the fact states that through a satellite imagery analysis, we found out that there is extensive construction. So if there's extensive construction, then there could be something. There could not have been enough data to give. Okay, that could also be one of the conclusions. But if we need something to to make sure that these projects will not affect us, right? Considering that they've not shared this, and that these diversion projects, as stated by the opposing counsel, could be of 15 to 20 years, the harm that Arcadia would suffer is going to be more, because since they are the upper riparian state, they are the ones who are going to receive the flow of the river first before the flow of the river comes back to us. So
but let's say we agree let's say this point is made, but then does this treaty allow us to award you speculative damages? What is our authorization to do so?
Well, to my knowledge, the treaty does not exactly provide whether this tribunal can provide us with speculative damages or anything in that regard.
What about customary international law?
Well, as pointed out by my co-counsel through the Chorzo factory case, we contend that this tribunal could use the Chorzo factory case's general guidelines as to reparation, and make sure that we are compensated accordingly.
Yes, but that requires full reparation, and full reparation is possible if there is real damage, something quantifiable. So you're supposed to be fully, effectively, efficiently repaired. Again, we are now speculating, so the Chorzo factory case doesn't give us a basis for speculative damages.
Right. So then the tribunal could provide us with speculative damages on the merits of our case, and on principles of justice, equity, and good conscience. And
so you want us to establish new customary international.
Yes. If this tribunal feels that new customary international law is required, well, we are more than happy to ask this tribunal to make the same point.
Well, thank you for entrusting us with this. We're going to have to deliberate. That's a heavy burden to bear. I'm sure my colleagues will agree.
Yes.
Sorry, Albin, can you guide us on the time? Because we might have actually exceeded. We want to be fair to the other side as well.
Yes, Professor, dear arbitrator. The other team has 2 more minutes for their rebuttal, and the team that we were talking are done. Absolutely.
All right.
So
yes, we're really sorry.
Would like you could provide them 2 more minutes. Thank you.
Yeah. We might want to add then 2 more minutes to the other side as well. I think we have heard from this, if my co-arbitrators agree.
Yeah, they have several also.
Thank you for permission, sir.
All I would say is I think they had their 5 minutes for rebuttal. Obviously, it was extended because of our questioning. I think the 2 minutes still stands unless, obviously, we raise questions and it's extended a little longer. So I don't think we need to change.
Sir, arbitrator, every time you asked, I was holding the time stop.
Correct. Right. No. But the 2 minutes, yeah. So I wasn't sure if the proposal from my colleague was to extend the basic 2 minutes that's allocated, because I think we stick to the timetable, give them 2 minutes, but of course, if we raise questions, then that is not counted as part of the 2 minutes.
Agreed, yes.
Much obliged, tribunal. So the council would like to cover all the facts and all the rebuttals under the 2 minutes. So the first contention was the long timeline, as highlighted by speaker number 1. Now, it is a statement of fact that both the countries have never seen this issue arise before. And since that, yes, we have taken 4 long years for replenishing our depleted water reservoirs, but it is an established fact that none of the countries had prepared for this natural calamity and force majeure event. Second is the data sharing prospect that they have shared. Now, it clearly states that Article 7, Clause 2 states that if the other parties of the opinion, so there is no need to share the.
Mr. Counsel, I mean, Don't try to attempt to confuse the tribunal. Where does this force majeure come in now?
Sir, a force majeure event means that any event
Part of the
outside the human.
Does the
Yes, sir.
treaty have force majeure clause?
No, sir.
Why are we talking about force
That is
majeure?
a general principle of law. Force majeure is a general principle of law.
Force majeure is a contractual remedy. Unless it is there in the treaty, we can't be talking about it.
Sure, sir. So, for a lack of better wording, I would use that, yes, unforeseen event, unprecedented event. Does that satisfy the court of arbitration?
Please go ahead.
Much obliged. The next contention that they highlighted is the duty to cooperate, and I think we have showed it time and time again that yes, we have abided by this principle of international law, even after multiple standoffs and multiple geopolitical changes that we have faced, which is also established in the statement of facts. Next is that yes, the speaker number 1 has highlighted that report shows confusion, and that the whole issue number 1 presented by the speaker number 1 is nullified, considering that the annexure 2 3.3 clearly state that we have adhered to the principles of the Waters Treaty, and there which is not of persuasive nature, but we have to abide by it, even the court of arbitration, which means that there has been no treaty violation of the treaty obligation. Next, the speaker has highlighted the Chorjur factory case as a general principle for reparation. Now, this is the same case which highlights that there needs to be a direct causal link between the alleged harm and the alleged action that caused the harm, which they have failed to establish. Other than that, the speaker has highlighted that the convention is not applicable. Now, statement of facts clearly state akin, the word akin in the background, page number 1, which means that yes, all the similar facts in the real time will follow in our present case as well. Other than that, the claimant has asked the tribunal as to how they can establish the claim, and it is not the duty of the tribunal to tell the speaker how to approach the court of arbitration. And lastly, they have also highlighted to establish a new customary norm, and I think my learned friend over here is not really familiar with what customary international law is. It is the principles which are immemorial in time and have been accepted generally in the international law. So covering every single rebuttal that they have highlighted in their submissions, the council has covered every single thing. And if the tribunal is of the opinion that it needs more clarification, the council would be more than happy to provide a clarification on that. Tribunal?
Yeah, thank you.
Much obliged.
You also have the surrebuttals.
Yes, but on my screen, teams are spent their whole time, sir. Both for the rebuttals and the sub-rebuttals.
Okay. I think we can go to a breakout room and confer as arbitrators.
Thank you so much, teams. Before you receive your feedbacks, you will be taken in the breakout room. Once arbitrators are ready to give feedback, you will be taken back to your room.
Thank you, Tribunal.
Garima, I think we should also go to a breakout room.
Sure, sir. You don't want anyone from the organizing team or the moderator to be there in the room, right?